Good morning and welcome to the March 21st, 2022 Land Use Hearing Officer meeting. I'm Pamela Jo Hatley and I'll be the Land Use Hearing Officer today. If you would all please stand if you're able for the Pledge of Allegiance first. All right, thank you, and good morning again. I'm Pamela Jo Hatley, the Land Use Hearing Officer for today. And I would like to first introduce Mr. Tom Hisney of the Development Services Department, who will introduce staff and any agenda changes, withdrawals, and continuances.
Yes. Good morning, Madam Hearing Officer. My name is Tom Hisney with Development Services staff. To my left is Carmen Mason with Development Services staff. We also, on the far left, have Israel Monsanto with Development Services staff. During the course of the hearing, we are going to be joined by other members of Development Services staff as they present various cases virtually, and I'll introduce them as at the time of those cases. We're also joined by county attorneys, Mary Dorman and Cameron Clark, and they will be participating virtually. I have one change to the agenda today. It pertains to agenda page 8, item H7, variance 22-0475, Daniel Jones of DR Jones Holdings, LLC. The zoning identified for the property on the agenda is in the correct zoning is CPV-A5. Now we have published withdrawals and continuances, which I'll now read into the record. Item A1, special use application 21-1344. The applicant is Crown Castle USA. This application is out of order to be heard and is being continued to the April 25th, 2022 Land Use Hearing Officer meeting. Item A2, special use application 22-0027. The applicant is Mocha Asian Cuisine. This application is out of order to be heard and is being continued to the April 25th, 2022 Land Use Hearing Officer meeting. Item A3, variance application 22-0079. The applicant is John Saldana. This application is being continued by staff to the April 25th, 2022 Land Use Hearing Officer meeting. Item A4, variance application 22-0350. The applicant is Jennifer Ronneberger with Go Permit. This application is out of order to be heard and is being continued to the April 25th, 2022 Land Use Hearing Officer meeting. Item A5, variance application 22-0446. The applicant is David Wright of TSP Companies. This application is out of order to be heard and is being continued to the April 25th, 2022 Land Use Hearing Officer meeting. And then the last item, A6, special use application 22-0481. The applicant is Sunset Dreams Winery. This application is being continued by staff to the April 25th, 2022 Land Use Hearing Officer meeting.
Thank you, Mr. Hisney. All right, so before we get into the hearings this morning, I would like to read some meeting procedures. First of all, if you have any electronic devices that make noise, please silence those at this time. The agenda today consists of items that require a public hearing by a hearing master. I will conduct a hearing on each item today and will submit a decision within 15 working days after the conclusion of today's public hearings. My decisions will be filed with the clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. The order of presentation today shall be as follows. For variances, Mr. Hisney will call the case. County Development Services will have 5 minutes to present its report and findings. The applicant and applicant's witnesses will have 15 minutes to present the proposal. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. For special use cases, Mr. Hisney will call the case. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. County Development Services will have 5 minutes to present its report and findings. The Planning Commission will have 5 minutes to present its finding of compliance or non-compliance with a comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. And the county staff will have 5 minutes to present any amended findings or comments. And the applicant will have 5 minutes for rebuttal and summation. The 15 minutes that are allotted to proponents and opponents is the total time that will be allotted among them. So if there are a number of persons who wish to speak, the 15 minutes will be distributed among you. If there's a number of persons who wish to speak on any item, you may designate a single spokesperson to represent your views. When you come to the microphone to speak, please first state your name and address for the record. The meeting today is being recorded, so please speak into the microphone so your testimony can be heard and recorded. When you're finished speaking, see the clerk to my right here to sign in for the record. Now we'll hear from the County Attorney's Office, who will state the legal requirements and procedures for appeal.
This is Mary Dorman from the County Attorney's Office. This Land Use Hearing Officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the County Attorney's Office to ensure that no new evidence or testimony is allowed before the Appeals Board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the Appeals Board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the Appeals Board that is outside the record created at today's hearing could jeopardize the legality of the Appeals Board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the Appeals Board.
Thank you, Ms. Dorman. All right, all testimony taken today must be under oath. So if you plan to speak today, please stand if you're able, raise your right hand, and I will swear you in. Those who plan to appear virtually, also please raise your hand to be sworn in. All right. Do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you. Mr. Hisney, would you please call the first case?
All right, we have no vestige rights cases or fee waiver requests today, so that's going to take us to Section D of the agenda, remands. We have one case, item D1, variance application 21-0586. The applicants are Irene and Jose Davis Santana de Jesus and Alejandro de Zerzik. They are requesting a variance to easement access requirements. By way of background on this case, the subject variance request was originally heard at the May 24th, 2021 Land Use Hearing Officer meeting. The requested variance was approved by the hearing officer on June 14th, 2021. An appeal was filed by a party of record and heard by the Land Use Appeals Board on December 10th, 2021. The LUAB remanded decision back to the land use hearing officer to reconsider variance review criteria 1, 3, 5, and 6. At this time, I'd like to introduce or call on county attorneys to address the hearing officer on the nature of this hearing.
Thank you, Mr. Hisney. Will there also be a staff report read?
Yes, after
Thank you.
the county attorney comments.
All right. Thank you.
Thank you, Mr. Hisney. Madam Hearing Officer Cameron Clark, Assistant County Attorney. This is a remand hearing that's come down from the LUAB. Therefore, your focus today will be on the numbered criteria that Mr. Hisney just identified in his introduction. This is noticed as a public hearing. Unlike a remand hearing, unlike an appeal to the LUAB where the record is locked from the LUHO to the LUAB, this is renoticed as a public hearing. The LUAB wants to seek additional evidence on the identified criteria that are in the LUAB remand order. If you have any questions, I'm happy to take them. Thank you.
Thank you very much, Mr. Clark. All right, we will hear from the staff report at this time. Thank you, Mr. Sir, please step aside. We're going to hear from the staff report first. Thank you.
All right. Staff findings in this case will be presented by Colleen Marshall.
Good morning, Colleen Marshall, Development Services. Tom Hisney has provided the background on the variance. The request itself is a 10-foot reduction to the required easement width to allow for a 20-foot wide easement to serve 2 dwelling units. Happy to answer any questions.
Thank you very much.
Ms. Hatley, may I address you now?
Please.
For the record, my name is Mark Bentley, 401 East Jackson Street, Tampa, 33602. I represent the appellants, as you're aware of. In the case, we object to the case going forward today. If you look at the order of the LUAB, they did not indicate that they wanted to reopen the case at all. They actually said they wanted to remand it. First of all, this is an appellate proceeding, and the record is locked at this point in time. There's nothing in the code that says to reopen the appeal. There's nothing in the LUAB order that says for you to take new evidence and have a new case with respect to the criteria. And with respect to the county attorney does not represent you under the Land Development Code. If you have any questions or concerns on legal matters, you're entitled to your own representation.
Mr. Bentley?
Yes.
Can you cite to the code, please, what sections of the Land Development Code, Hillsborough County Land Development Code, are your objections based on?
I don't have the code in front of me, but I'll just say generally on appeals, I don't see anything about a remand for a new case. But I'm saying,
Mr. Bentley, Mr. Bentley.
Yeah. Looking at the LUAB's order, there's nothing in there. They remanded it, and they actually said for you to revisit the record, okay, that's already established, and to verify information. Verify means verify what's already in existence, not new information. So I just had to get my objection on the record. Thank you.
All right, Mr. Bentley.
Yeah.
I have the LUAB's order in front of me. And as you're aware, when an appellate court remands a case to the trial court with instructions, that trial court is bound to follow the appellate court's instructions. In a similar manner, I am bound to follow Land Use Appeals Board's instructions to me. I have the order before me, and they have listed, the Land Use Appeals Board has listed items of the 6 questions, and they have instructed me to revisit those questions, not to revisit the record only, but to revisit those questions. And so that's what I will do
Okay.
today.
So your,
Thank you, sir.
so your interpretation revisit is to open up the.
Mr.
the case.
Bentley,
Okay,
this is a public hearing, and I will hear evidence today on those questions.
okay.
And you're no longer recognized. I will hear from the applicant at this time.
And
Thank you, sir.
just one point, since we're limited to those criteria, the applicant has filed information that goes above and beyond those criteria. I just want to get that in the record. Thank you.
Mr. Bentley, I'm aware, and step
thank
forward,
you.
please, to the microphone. Mr. Bentley, please step forward to the microphone. Among those issues I will explore today are the code enforcement the code enforcement cases, which you brought up to the Land Use Appeals Board, did you not?
Yeah,
You did. And those were not in the record before the land use hearing officer. I have read the record repeatedly. So I will hear evidence
well,
on
the
those
reason
as
they
well.
weren't is that they didn't fulfill their obligation under the code to give you copies of the notices of violation. Also, their building code violations in existence, which I'll present to you today. Thank you.
Which you submitted into the record in addition, which were not before the land use appeals
But they'll
board.
be before you today,
Which were not before the land use hearing officer.
but they'll get in the record today. Thank you.
Thank you, sir. Yes, thank you. Mr. Bentley, please sign in with the clerk's office. The applicant, come forward, please.
Good morning, Isabel Albert with Half Associates, 1000 North Ashley Drive. I'm here representing 2 owners that are living on the east side of this property to whom Mr. Bentley is representing. This is a very awkward situation. My client,
Ms. Albert,
yes.
one moment. Who do you represent? Could you name them, please?
Yes, I represent Alejandro Jurizik. He lives at 8710 Hyder Jane Lane. And the Santana de Jesus that lives on 8704 Hyder Jane Joe Lane.
All right, the owner of 8704 Hyder Joe Lane.
Yes,
They are the same owners, aren't they, who were part of the applicants, part of the original application?
that is correct.
And this variance application does affect that property directly, correct?
Correct.
All right, who is your other client, please?
The other client is a new property owner that purchased the property after the variance was approved.
Okay, what is that person's name?
Alejandro Jurizik.
All right, Mr. Jaruzik.
Yes,
All right, and Mr. Jaruzik is the owner of the property at 8710 Hyder Joe Lane, is that correct?
that is correct.
All right, and his predecessor in title was April Lott, Matthew Hyder, Jesse Hyder, and Richard Hyder, is that correct?
That was part of the record, and I would take that that is correct.
And they owned the property that was originally part of the application at 8704 Hyder Joe Lane, and that property is directly affected by this variance request. Is that correct?
That is correct.
Okay, thank you very much. Would you proceed?
Okay. So according to the LUHAM, we had to respond to number 1, explain how the alleged hardship or practical difficulties are unique and singular to the subject property and are not those suffered in common with others similar located. As previously presented, both properties are adjacent to privately owned properties to the north, east, south, and to the creek to the west. Their only access is from a 20-foot easement, which was created by agreement between the property owners of record in 1996 at the time of the easement was granted. The said 20-foot easement found in official record 8276 and page 1554 from Hillsborough County. This is also part of the record. Prior to this 20-foot easement, both parcels were accessed by a 30-foot easement that's been canceled and replaced by this 20-foot easement.
Ms. Albert, do you know who the parties to that easement document were?
It was between the Rays and the Hiders.
Okay, and when you say the Rays, are they property owners that are affected?
These are the property owners to, I guess, along, so their exact names are, sorry. It was Stephen Ray and Patrick Ray.
All right, they were parties to the easement.
To the easement granted to the Hiders.
Okay, and who were the other parties?
Just between those two.
Okay, they were the grantors, correct?
Correct.
Who was the grantee?
The grantee were the Hiders.
Okay, the owners of the property that is subject to this variance request, correct?
Both
Okay.
property owners.
All right, thank you.
So the hardship and practical difficulties are unique and singular to both properties and are not suffered in common with the other properties similarly located. And then they also wanted us to address number 3, explain how the variance will not substantially interfere with or injure the rights of the others whose property would be affected. This 20-foot easement at its current location has been serving these 2 lots since 1996. The 20-foot easement is a replacement of a 30-foot easement. And by allowing the variance, the easement will remain in its configuration and use since 1996 and will not substantially interfere with or injure the rights of others whose property would be affected by allowance of this variance. Explain how the situation sought to be relieved by the variance does not result from an illegal act or result from the action of the applicant. This is not a self-imposed hardship. The 20-foot wide easement was created between the property owners of record in 1996. And the new owner has looked into the record to see if there was an existing easement, and he found that document, which is what he referred and used in order to purchase the property. Therefore, the situation sought to be relieved by the variance does not result from an illegal act or result from the actions of the applicant. And explain how allowing the variance will allow substantial justice. Allowing the variance will result in substantial justice being done by allowing the applicants to continue enjoying access to and use of their home properties, which does not interfere with other properties. There are some questions whether or not it's 1 lot or 2 lots or stuff like that. It is going to be serving, this easement is going to be serving 2 units. Those 2 units are owned by, one of them is owned by the Jurassic and the other is owned by Santana de Jesus.
All right, Ms. Albert, thank you. This is one thing that the Land Use Appeals Board had questions about. And so let's explore that a little bit more.
Okay.
So first of all, the easement provides direct access to a public road.
Mm-hmm.
To how many parcels?
There are 2 parcels.
Okay, 2 parcels or 2 lots.
2 lots, correct.
Okay. How many units are on those 2 lots?
1 on each lot.
So there's 1 dwelling unit on each lot.
There is going to be, so my client purchased the property.
Which client?
Sorry, the Jurassic.
Okay.
Okay, purchased property
At
8710 Hyder Jane Lane. And he applied for getting a building permit in order to upgrade the house. And during that time, this is when he found out that you can only have 1 unit at this property. So therefore, the building permit is to convert the duplex triplex into a single family unit. And he is here to confirm that. He flew from Texas to make sure that everybody understood this is going to be 1 unit.
Okay. How many units were there before your client purchased the property? How many units were there at 8710 Hyder Joe Lane?
I have not gone to the property, but if you look at the property appraiser, which was also in the record, sounds like it was a triplex.
And what evidence do you have that it was a triplex?
Whatever was in the record. And the client also said, yes, apparently it was a triplex. He hasn't seen the property, it's not from here, but he's been converting it to a single family unit.
Okay, your client is here today, Mr. Jurassic,
Yes.
and he has not been to the property? That's okay. We'll ask him to come forward. Please ask your client to come forward.
Can you please come forward? Thank you.
Thank you, sir. Please state your name and address for the record.
Alejandro Jurisic, 199 North Hazel Crest, Spring, Texas.
And Mr. Jurisic, do you own the property that we've identified as 8710 Hydrojo Lane?
I do.
Okay. Have you seen that property?
I have.
Have you been in the structure on that property?
I have.
Okay. In going into the structure on that property, have you been, I understand there's an upstairs and a downstairs. Have you been to both the upstairs and downstairs?
I have.
All right. And from your visual inspection of the property, how many dwelling units are there?
So when we purchased it, it was supposed to be a triplex.
It's supposed to be a triplex.
Yes.
Okay. Is anyone living there now?
No. We're in the process of getting permits to convert it into a single family because we were told that by a permit, it could only be a single family. It couldn't be a triplex.
So you're in the process now of converting it to a single family home?
Yes, ma'am.
Okay. And what do you intend to do with it in the future?
We intend to move and live there
You're going to move there and live there
Mhm.
as a single family dwelling?
as a single family dwelling. Yes.
Okay. Are you aware of any open active code enforcement cases?
We got a notice that when we purchased a property and we began doing paint work and all inside, we got a notice that it was, there was a permit violation because we didn't have because it was supposed to be a single family and not a triplex. So I called the county office and it was really confusing because the appraisal office had it as a triplex, but apparently the county had it as a single family. And we didn't know that when we purchased the property. So we were told it needed to be a single family. Obviously, our plans changed, so we contracted a contractor and he began filing for permits to convert it to a single family. And we're in the process of getting those permits approved right now.
So again, back to my question, are you aware of any currently open code enforcement cases?
Not that I'm aware of, no, ma'am.
You are not. Thank you, sir. All right, that's all the questions I have for you right now, Mr. Jurisic.
Thank you.
Thank you. And sir, please sign in with the clerk right here. Thank you. Yes, Ms. Albert, go ahead.
If you had any questions or whatever time I have, I'd like to remain it for a rebuttal, but
Looks like there's about a little over 5 minutes left that you can reserve for rebuttal.
I think so, yes.
Okay.
Thank you.
Thank you. All right, is there anyone here or online who wishes to speak in support of this case, this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application?
Start the meter out here. Once again, my name is Mark Bentley, 401 East Jackson Street, representing the Rays, who are the grantors of the easement in question. Just want to point out that they did not present any building permit applications. And I'll show you actually the comments from the building department. And there is a pending violation at this point in time, or 2 pending violations.
Mr. Bentley?
Yeah.
Are you saying that there is an open code enforcement violation?
Yeah, it's not,
And please just, there is or there is not?
there is.
Okay.
According to records I
Okay.
have.
When was the code enforcement complaint filed?
I don't know when the complaint was filed, but the documents, if you would let me go through, I could explain this coherently, and then instead of being interrupted, then it all makes sense.
Mr. Bentley, when I have questions, I'm going to interrupt you, sir. And I need you to be on the microphone.
I got you. Let's just right up front. Okay, you look in these documents that I provided you. If you look toward the back, you'll see from the building department, HCCMP 21000005228710 Hyder Joe Lane, and that's the notice of violation. There's two of them. And then the third, while we're at it, the third document after that, it says, Ms. Hatley, and I'm showing this to you, is 8710 Hyder Joe Lane. And on page 2, it says that the triplex sits on a double lot. The seller would be responsible to break the lot into two, and we'll keep
Okay.
the extra lot.
One moment, Mr. Bentley. Let's go one at a time. The first thing you pointed out was a document titled HC-CMP-21-00000522, 8710 Hyder Joe Lane. What is this document?
It says residential building code compliance case, awaiting client reply, concern of the illegal triplex use in single family zoning district RSC.
Is this a code enforcement document, Mr. Bentley?
Yeah, it is. It's
Okay.
through the building department though. It's kind of,
Okay, one moment, please, just one moment.
on these questions,
One moment, Mr. Bentley, please don't speak away from the microphone.
I just
Thank
don't
you.
want the time held against me when you're asking.
I understand. Thank you.
Thank you.
Okay, Mr. Bentley, go ahead, please.
Okay, thank you. So we kind of dealt with that,
Please.
a little out of order, but in any event, I wanted to point out the staff report from the original case that you heard and the one at issue right now are a little different. Under variances, it says per LDC 602, an access easement urban service may serve a maximum of 3 lots. If you look at the code, that relates to a subdivision, which we're not dealing with. And then,
Oh, wait just a minute.
Mhm.
Are you talking about the current staff report?
yes, ma'am.
Okay. All right, so the staff report says that under Land Development Code Section 6.02.01.5.b, an access easement in the urban service area may serve a maximum of 3 lots. And per Land Development Code Section 6.02.01.b.5.c.2, a minimum width of 30 feet is required for an easement serving 2 or 3 dwelling units. The applicant requests a 10-foot reduction to the required easement width to allow a 20-foot easement. So what is wrong with the staff report? Are you saying something's wrong with the staff report?
That's good. Hey, thanks, guys. I'm not saying it's wrong, but the first section here, the new sentence that was added in the new report relates to when you look at the code, and I've given you a copy of that in the materials I provided you.
You're not speaking into the microphone, Mr.
In the
Bentley.
materials I provided you, I gave you a copy of the code. And my point is, there's a distinction between lots and units. So this first sentence, when you read the code, relates to subdivisions. Okay? And this is not a subdivision. So the second sentence is a mirror image of the original staff report. And that's what they requested in their variance application. Now, the reason
Mr. Bentley, are you saying that this section doesn't apply?
well, it could apply if it was a subdivision, but,
Well, but
okay,
this is 2 lots.
okay. But my point, Ms. Hadley, is there's a distinction between lots and units. And even in your order, you didn't make that distinction. I want to point that out to you. There's a little confusion.
Okay, let's just pause a second here.
Is this working, guys? Test. Everything's good? Okay.
So this section of the code, 6.02.1, I'm sorry, 0.01.5.b, also states that no easement shall provide access to more than 3 lots. So here we have 2 lots. So an easement can provide access to these 2 lots. Do you agree? Thank you. All right. Then in addition to that, subsection C refers to width requirement. If the easement serves 1 dwelling unit, a minimum width of 20 feet is required. And 2, if the easement serves 2 or 3 dwelling units, a minimum width of 30 feet shall be required. So do you agree? Here, if there are 2 dwelling units, that a minimum width of 30 feet is required.
Yeah.
Okay.
Okay. I was just pointing out this distinction about the first sentence, the difference, because your decision was a little confusing on this point. On page 1 of your original order,
Are you referring to the table on page 1 of the order?
on page 1 of your original order, you mentioned lots.
Mr. Bentley, is that the table? It's configured as a table?
It's just on the first page of the order.
Yes, sir, but
Yeah.
let me just show it
I
to
think
you
it's the
then.
table. Mhm.
Right.
And then on page 12F,
Just 1 moment. You're talking about this page 1. It's
Yes, ma'am.
configured as a table. Okay. This page 1.
yes, ma'am.
That information comes directly from the agenda.
Okay.
That's not part of my decision, actually.
Okay.
It's just an introduction.
That's fine, because then when we get to page 12F of your decision, that's where you say units. Okay, make that distinction between units versus lots. I just wanted to point out.
And we've read the section of the code that does say an easement can provide access to up to 2 lots and to 2 dwelling units.
Correct,
Okay, so we're good. We're good there, right?
exactly.
Okay, good.
So I'll get into these code things and actually the property being marketed online as we speak for splitting the lot and a triplex. And they're building code violations right now as a triplex. Whether or not they're trying to reconcile that, they haven't provided any evidence except verbal testimony. But what I wanted to point out to you is the board, the LUAB, was searching for new evidence to support those few criteria that they referenced in their order. So when I was getting prepared, I noticed I took a copy of your order from last year and compared it to the, I guess, appellees at this point, response to the variance request.
The appellant, the applicant?
Yeah, well, I'll call them applicant. That makes
They are
sense.
the applicants,
Yeah.
yes.
They could be an appellee, but we'll just leave it applicant. But, so what happened?
All right, speak into the microphone, please.
So if you take a look, this is your order from last year. It can show up somehow. And these are your findings on the variance criteria. And so What the applicant did, I've highlighted the applicant's response contained within your order. So what she did is took out verbatim, I'm going to show you. She just fed your order back to you in her justification, which you characterize as findings on variance criteria. So on page 12, I just showed you. Here's page 13. Here's her response.
When you say her, who are you?
Miss Albert, the representative.
Okay.
Okay. Page 13. Here's her response. Okay. Now they changed a couple words or put a couple commas here. So I was actually kind of pretty generous. And then look at page 14. Identical to your findings or conclusions.
Okay.
And that's how they respond to the criteria.
What is that relevant to, Mr. Bentley?
Because the board was searching for new information and she turned around, this lady, and gave you,
I'm sorry, this lady, who are you speaking?
Miss Albert,
Okay,
I'm sorry, the applicant, representative,
okay.
and gave you back exactly what you had in your order, which does not help things in terms of searching for this new information to resolve their concerns about some of the criteria. She gave your verbiage directly back to you.
Okay, Mr. Bentley, that's fine. I understand that point. The Land Use Appeals Board has requested that I address the number of units. And I believe that has been addressed this morning. Right?
And then with respect to, they had concerns too about the legality of the lot split. And we went down that path.
And that is not an issue that I can even address.
Okay, we have that in the record.
All right, Mr. Bentley,
Okay,
the Land Use Appeals Board did instruct me to explore potential misrepresentation early on in the case. What evidence do you have related to that?
okay, what I have document I just,
Speak into the microphone.
it's a document I just provided you. And it's, Ms. Hadley, it's this one. Okay. And it's
What document is that?
titled Exhibit Submitted by Mark Bentley at May 24th Luho Hearing on Variance 210586.
Okay, I have it.
Okay, if we go to, is this working, guys? Okay, great. If we go to Exhibit 4, this is a letter from the county directed to Mr. Hyder, who had applied for a permit to build a single-family home and split the property. Now, back to the easement, the Rays granted an easement to one property owned by Hyder, not to a subdivision, not to owners. It just said granted to the Hyders one lot.
No, sir, let's explore that. You're talking about the original access easement?
Yeah.
Okay, do you have that document?
No, but let me,
I have that document, so let's talk about that document. And I'm going to grant another 5 minutes, please. One moment, Mr. Bentley, I have it. Just let me find it.
I have it in my files if you're having difficulty.
Yes. All right. Would you please read the description of the property that was owned by Hyder at the time?
It's on page 2, paragraph 2. At the top here.
Yes, that was owned by Hyder.
Correct.
The property owned by Hyder is the property that is benefited by the easement. Is that correct?
Correct.
Would you please read that?
You don't want me to read the legal, do you? Just
Yes, sir.
Parcel 1, east 100 feet of the west 648 feet, the north 1/2, the south 1/2, the north 1/2, southwest 1/4, the southwest 1/4.
Okay, and then below that it says parcel 2, correct?
Correct.
Okay, so that easement was granted to the property that was owned by Mr. Hyder at the time, and it's described as parcel 1 and parcel 2. Is that correct?
Correct.
Is there anything else you see on that document that states that it's limited to one parcel?
No, it just says the property, and then it says the north 20 feet.
Oh, all right, so that's the description there of the width of the easement. But that easement access, doesn't that document provide easement access to those 2 parcels owned by Mr. Hyder that are described there in the document as 2 parcels?
Well, the intent was not to overburden the easement, and at the time of the conveyance of the granting of the easement to Mr. Hyder, there was 1 house and 1 lot on the property. It was never contemplated be subdivided.
There's nothing expressly stated in that document there that says that those 2 parcels couldn't both contain a dwelling unit, is there?
No, I agree with that.
Thank you.
Can I move on here? Then we'll.
Yes, please.
Okay, back to this letter here, the county certification letter to allow this lot split, to allow development of a single family home at 8710 Hyder Lane, which is the house that we've talked about. It says that at the end of the letter that it's boilerplate that it should be recorded, but the important thing here is the legal description, and this was submitted by the applicant, Mr. Hyder, Hillsborough County Development. He says it's the north 30 feet, okay, which is incorrect.
And where did this legal description come from?
It came from the Hyder's application. I got it through a public records request through Hillsborough County.
All right, do you have records clerk, or is this certified document or anything?
I don't know, in the first batch of documents I gave you at the first hearing, none of them are certified. All I can do is attest to you that they were in response to a public records request that I received from Hillsborough County. And then I'd like to go to the next document. As part of the application, you can see here is a sketch. And what the Hyders did is you can see all the numbers here are in AutoCAD on this drawing. And then it says existing driveway. You can see where I'm pointing my finger. Someone wrote in 30 feet. And you can even see it's on.
Mr. Bentley,
Yeah.
you said the Hyders did this. What evidence do you have that the
It's part
Hyders
of
did
the
this?
I'll show you. It's part of the application that was submitted by Richard Hyder.
Okay.
Okay.
And Mr. Bentley?
Yeah.
On that document that you've got your finger on?
Yeah.
Where it says 30?
Correct.
Okay, put your finger back on the 30, please. And move your finger over to what is, for me, the right side of the document towards the, there you go, a little further. And up just a little bit. And a little further over. You see where it says 130? No. Your finger goes up and then just under the north indicator, just a little, okay, there it says 130 feet.
Mhm.
And that looks like it's handwritten as well. And then toward the bottom, directly under that, it looks like 130 is handwritten as well. So there are several places on this document that appear to be handwritten. Do you know for sure who wrote those things?
No, I can't say Mr. Hyder did.
Okay.
But
You cannot say who wrote those things, is that correct?
all I can say is this, is we've gone through the facts that the easement was recorded prior to the certification, and the easement said 20 feet on the north side. The application of the Hyders, okay, and the exhibit attached to their application for certification and for a single-family building permit indicated 30 feet. It looks drawn in. Everything else is in AutoCAD, and you can even see the 30 feet. It would be out of scale with, looks like the other dimensions here.
Okay.
And that's my testimony. Now, the next
Mr.
thing-
Bentley,
yes, ma'am,
you're representing
the raise.
Stephen and Patrick Ray, is that correct?
Yes, ma'am.
Okay. Are you representing them as their attorney?
Yes.
Okay. Mr. Bentley, in a court of law, these documents that you have showed me here in Exhibit 4, would these documents be considered hearsay if they're not certified or if the records clerk isn't here to authenticate them?
Yeah, but this is very unusual what you're asking me, because the code says this is an informal proceeding.
That's
You
correct.
can even accept hearsay, and my testimony is an attorney under oath, okay, certified by the Florida Bar, is I received these documents from the county in response to a public
Thank you.
records request.
Mr. Bentley,
And I submitted them back to the county for analysis, and they did not dispute.
as an attorney,
Yeah.
providing argument today, is your testimony competent substantial evidence?
Well, my legal opinion,
Okay, thank
Okay.
you.
now, I'm a certified planner, but a planner's,
But
there's.
you're speaking as an attorney today, though,
I
right?
am. But-
Thank you.
But what I'm telling you is a planner is not competent to interpret legal instruments. So any testimony from Ms. Albert, okay, she's not qualified to give testimony on legal issues.
Mr. Bentley,
If you want to carry it that far,
let me ask you, please,
Sure.
are you aware of case law that holds that argument of attorney is not competent substantial evidence, aren't you?
yeah, I'm just submitting these documents.
Thank you.
okay? I don't need to argue. The documents speak for themselves. I'm pointing out some discrepancies for your consideration. The board was concerned about the legitimacy of that lot split, and I'm giving you some information to help you make an educated decision.
Thank you. Do you have any other,
Yes, ma'am.
one moment, let me finish my question, please. Do you have any other evidence on potential misrepresentation early on in this case?
Yes. And then the next, if you turn the next document over, here's April Hyder granted a perpetual easement to either Tico or the county. If you look,
What document are you referring to?
it's the last, next to last order determining homestead status of real property on the petition of April Hyder.
All right, go ahead,
Okay.
please.
If you look at the bottom, we all agree, I think in this, that we're dealing with this issue, that the easement is 20 feet. That's why they're here today, to see if they can get a reduction from the 30-foot requirement. But April Hyder, she then grants perpetual exclusive utility easement for installation of water lines to Hillsborough County for 5 feet.
All right, Mr. Bentley, let's explore that a bit. Where does it say on this document? And this document is Exhibit 7. It is an order determining homestead status of real property. And the final paragraph on that page, the front page, says a perpetual exclusive utility easement for installation, repair, and maintenance of water lines over and across the north 5 feet, and so forth. It finishes the legal description. Where does it say that any easement was granted to Hillsborough County?
No, I'm just saying, I'm assuming if it's a water line, okay, that probably to the county. But my point here is.
Well, wait a minute. So you're assuming there is a grant of
Yeah.
utility easement to Hillsborough County.
Okay.
Okay. Are you aware, Mr. Bentley, are you aware of any easement that was granted by the Rays to the Hiders for a utility easement?
No, I'm not.
Well, if there were, and looking at the legal description on this document, in this paragraph, you pointed out this utility easement. Isn't that an easement over the Rays property?
Yeah, but here's.
Okay, and let me finish my question. In order to grant a utility easement over the Rays property, wouldn't the Rays have to do that?
You've hit the nail on the head.
Okay, thank you. Then I have another question for
Okay.
you. Are you familiar with a document recorded at Official Record Book 10584, page 0275, wherein Stephen and Patrick Ray granted a 5-foot utility easement to Richard Hyder? Are you familiar with this document? I have it if you would like to see it.
No, I'm not familiar with it.
Okay. Would you like to see it?
Okay. My point is, yeah, I'd like to see it.
Would you?
Okay. And then,
Or would you?
but,
Mr. Hisney will provide that to you.
okay, if we can carry on this document here, the point is, this is a perpetual exclusive easement.
And that's the
And there were
easement.
20 feet here, and now this is for 5 feet. So since it's
Please
exclusive,
examine that document, Mr. Bentley, and tell me if,
why do you keep interrupting me? Can I answer a question?
Mr. Bentley,
I think you're denying my clients the due process here.
thank you. I'm exploring evidence that the Land Use Appeals Board instructed me to explore. Please look at that document.
Uncertified copy. Okay, so you have an uncertified copy of.
Is your client here, Mr. Bentley?
Pardon me?
Is Mr. Ray here?
I'm not sure if Patrick or Steve or,
Okay, could they come forward, please?
they're going to testify in a minute.
No, sir, I want to hear from them now on this issue.
Okay.
Mr. Bentley, would you please have Mr. Ray look at this document after they identify themselves in the microphone? You need to turn that microphone on and the other one off. Thank you.
I'm Steve Ray. I own the property at 6913 Sheldon Road, Tampa.
Thank you, Mr. Ray. Would you please look at that document and tell me, is that a utility easement that you granted to Mr. Richard Hyder?
See it?
Yeah, but are you in a position to interpret a legal description that relates to this 5-foot easement?
Mr. Ray, is that your signature on that document?
Yes, it is.
Okay. And the other gentleman behind you, would you like to identify yourself for the record, please?
My name is Patrick Ray.
Thank you, sir, and your address?
6913 Sheldon Road.
Thank you. Mr. Patrick Ray, have you looked at the document that we're looking at there, and is that your signature on it?
That is my signature.
Okay, so Mr. Patrick Ray and Mr. Stephen Ray, the question to both of you. Did you grant a utility easement to a water easement or something across your property to Mr. Richard Hyder?
It apparently looks like that's what this document says, although I don't recall that being in it, but it looks like it is.
What was your intent in signing that document at the time?
Well, this is part of a bigger document for the easement, I believe.
What's the date on this document you're holding there, please?
2000.
2001, 130.
Okay, 2001. And when was the
Sorry.
access easement
I'm
granted?
sorry, this is April 17th, 2004.
2004?
Correct.
Okay, when was where did you get that date, first of all, please?
It's where the signatures are at the bottom where there's a notification of a notary. Sorry, that's when it expires. I'm sorry,
All
ma'am.
right, that's the
I'm not
notary's
sure.
expiration date, isn't it? Thank you.
Yeah.
All right, just take a look at where it says the foregoing instrument was acknowledged before me this, it appears to be 20th or 29th day of January 2001 by Richard Hyder. That was the note, what the notary said. Or it looks like the 29th day.
Yeah, there's a documentation when it was put into order with the clerk on 1/30/2001.
So it was then in 2001, likely January of 2001, when you granted this or when you signed this document. Is that correct?
Apparently.
Okay. And when was it that you granted the access easement to the Hyders?
I believe that was back in 96.
Okay. All right. So the original access easement was in 1996.
Mhm.
And you granted the Hyders a 20-foot wide access easement across your property. Is that correct?
That's correct.
Okay. And then at this time, you granted them apparently a 5-foot utility easement
Within the 20 feet, I guess.
within the 20 feet.
Mhm.
Okay. And the purpose of that was what?
I guess so they could get water back there.
Okay.
The issue here, ma'am, is if I could just, I'm not an attorney, but I just like to speak my piece if I could. I wasn't really aware of any of the issues that was going on in the back of the property until we had to go through our own code enforcement, which was fine because our property was out of zone. It was zoned incorrectly. So it was brought to our attention. And so through a process, we made the correct revisions, and now our property is zoned correctly. So within that process of doing that is when a lot of this information became available, because we had to resurvey our property. And when all that happened, we noticed discrepancies, especially for me. The biggest one is that the fact that apparently, allegedly, I guess, it looks like when the Hyders or the previous owners wanted to build another structure there, they petitioned Hillsborough County to do so.
And just so I'm clear, build another structure. Was that the second house?
8710.
8710. Thank you.
Yes.
Okay.
And the county approved it. I mean, I wasn't part of that business, so I was under the understanding that everything is copacetic.
Okay. And when that was going on, Mr. Ray, you saw, of course, there was some construction back there. You saw, of course, that that activity was going on, didn't you?
I did.
Okay. Thank you.
And you know, between us right now, I didn't really have a problem with it at the time. But we're talking about legality, and when it was brought to my attention that a survey or a device used to get that approval from Hillsborough County was tampered with,
And who brought that to your attention?
my attorney.
And when you say tampered with, what evidence do you have that something was tampered with?
It was pretty obvious. The document says 30 feet. And if you go back to the amount of easement that we provided them in the original document, I guess back in, say, 96, it was 20 feet. So
the
something
document-
changed there.
So just to finish this out, the document says 30 feet, but you granted them 20 feet. So you said tampered with.
Changed something.
Okay.
And I didn't do it. I did not grant that.
So there's a mistake, at least. It says 30 feet and it's supposed to be 20 feet.
At the very least.
And your easement of record says 20 feet.
Correct.
Okay, thank you.
But, ongoing to that, we've gone through quite a bit of expense to bring our property correct in the eyes of Hillsborough County as a tax-paying citizen. I don't have a problem with that. This is what we should have done. We did it. What I do have a problem with is just say a device being changed blatantly to serve a purpose of the county being, I don't want to say coerced, but them having the evidence to say, yeah, we can go ahead and grant a building permit to these people because they have a 30-foot easement. That's not true. So that part I have a problem with as a tax-paying citizen.
Okay. But the building permit is not before me, and the lot split is not before me.
The fact that, I've seen on multiple occasions, emergency equipment trying to get down to that.
Multiple
Twice.
occasions, sir?
Twice.
Okay. And
One time when I actually talked to, it was EMT.
okay.
So they couldn't get down there. And being that when we had to reconfigure our property, we put new fence lines up, and that easement road it's not.
Okay.
Yeah.
So the road probably needs to be improved,
At the least, yeah.
Okay. And an emergency vehicle is certainly not 20 feet wide. So it's not a matter of the width. It's a matter of the road improvement. Is that correct?
You could say that, among other things. It just looks like to me, I'm not an attorney, and I don't do this for a living. I sell plants for a living. If you want a flower, I'll sell one to you. But to me, it just looks like due process on my part is not, it looks like the fact that Hillsborough County collects taxes, and that's what it's all about. It's just like me, the way I make money as a business owner. It looks like you're leaning more toward forgiving something that back in the day, maybe not the owner that bought the property. I don't have anything against anybody. And I feel bad for the owner who bought the property because I think he was sold a bag of goods, but it should follow the law. And it needs to be 30 feet, in my opinion, it needs to be 30 feet for more than one property back there.
Okay.
And it's more than one property.
And would you be willing to grant them another 10 foot across your property to make it 30?
Not at this time, because all of my property that I have is being utilized for my business. So any development that I might want to do in the future wasn't part of my plan to give up another 30 feet.
No, originally wasn't the easement 30
10
feet. I'm sorry. Originally wasn't the easement 30 feet wide?
Mhm.
And it was at a different location.
It was in the center of the property.
It was in the center of your property.
Correct, between the two folios.
And
We were approached by Mr. Hyder to the previous owner he's deceased. He approached us and wanted to move it to the north because he did not like the fact that he had to access, this is a long time ago, but he didn't like the fact that he had to access his property going through the middle of a commercial property.
okay.
So he approached us, we granted it. When we talked about it, I remember the conversation. I was the one, my brother and I are the one who executed everything. He was fine with the 20 feet because he wanted more narrow because he didn't want more people coming down there. And it was just him. He wanted to be secluded in his property.
So you and Mr. Hyder agreed to reduce it from 30 feet to 20 feet and move it to the north of your property, north side.
He's the one who suggested it.
Okay.
So
And while you're up here, I have a question for you. When you granted the easement, the intent,
Mr. Bentley, we can't hear you. I need to speak on the mic, and both of them won't work at the same time, I don't believe.
let me ask you, when you and your brother granted the easement to Mr. Hyder, what was your intention with respect to the use of Mr. Hyder's property? Was it for him to develop the property, or was it for just his one homestead property?
it was most certainly that his intent at the time was that he just wanted to live back there and be at peace.
Okay.
It was one property.
All right. All right. Thank you.
Do you have any more questions for me?
No, sir, not at the moment, but please sign in with the clerk's office.
Thank you.
One moment, Mr. Bentley, just one moment. Does that document need to be submitted to the clerk's office for the record? All right, we're submitting to the record the easement document that Mr. Patrick Ray and Stephen Ray looked at. That's recorded at OR Book 10, 584, page 0274, Hillsborough County. Go ahead, Mr. Bentley.
One of the
Thank you.
criteria would be, would the variance interfere with or injure rights of others whose property would be affected? You just heard testimony from the Rays, okay, that would, additional units would overburden the easement, which is just a dirt road. Also, they have plans to develop the property. So with that, in regard to that criteria, the applicant doesn't meet the criteria. So,
Mr. Bentley, a question about that.
Yeah.
Please pull the microphone down just a little bit so we can hear your testimony. Thank you. And there was testimony from the owner of 8710 Hydrojo Lane that will be used as a single family resident.
but we have to speak to the facts that are, you heard last time we had this case, there was testimony, there was a triplex, okay, that was unrefuted. There was a code violation, a copy of which I submitted to you, that it's a triplex. This gentleman may have good intentions of doing something. I think the appropriate thing would be to get his approvals and then come back and pursue a variance. Right now, he's just telling you, I'm going to convert this triplex. The documentation I showed you, even submitted to the county, still shows at best a duplex because there's no access between the top of the unit and the bottom of the unit.
Are you sure about that? Have you been inside the property, Mr.
No, but I'm just looking at the plans that were submitted to the county, okay? Take a look at them when you have the opportunity. So I'm just going to sum up in a minute, and then we'll just let you move on to the next case. So what you have here is an illegal lot that was certified by the county with 30 feet that's never been reconciled. Okay, so that's still sitting out there. Per county documents, there's an illegal triplex under citation. The property appraiser considers it, as we speak, an illegal triplex. It's just speculation whether or not. Right now, the county's waiting for comments for a couple of months now, based on the documents I gave you, for additional feedback from the now property owner. And what I provided you too is and I'll just
Speak into the microphone, please.
the one document I provided you from property report 8710 Hyder Lane. It's by Greystone, dated March 14, 2022. It says triplex. It's here again, it confirms triplex sits on a double lot, 20,000 plus square feet. The seller would be responsible to break the lot in two and will keep the extra lot.
I'm sorry, what is this document? Where did it come from, Mr. Bentley?
It came from Greystone, which is a property broker.
Did you order this document?
No, I didn't. I got it online.
So you don't know who prepared it?
No, ma'am. That might be a question you might want to ask the applicant on rebuttal. But
You don't know when it was prepared or who prepared it?
no, ma'am.
So this is just hearsay and we don't know really where it came from.
Exactly.
Okay, thank
Exactly.
you.
And to continue, the applicant has not provided any substantial competent evidence to support obtaining a variance and simply regurgitated your very own order from last year back to you, which as long as I've been doing this, I've never seen something like that. So
Well, sorry, what you just said was no competent substantial evidence. You mean those are the variance criteria response?
yeah, but what she did is you got nothing new from the applicant except testimony that they intend to convert a triplex. She took all your responses to the criteria in your order from last May, I believe it was, and put them in her responses to the criteria so she essentially gave you back your language, almost verbatim.
You stated that. Okay.
Yeah, okay, but you seem to question that.
That's repetitive.
I know it's repetitive,
Okay.
but it's very important is the board said, we want more information, go back down, okay, and investigate these issues. What does the applicant do? Is give you the same old information.
This is the hearing, and I have been investigating that. I believe you see, you've heard this
I
morning.
got you.
Okay.
So, just our position is they need to get their act together before they can even think of filing. You've had an illegal certification. You have these issues here with code violations, and that's it. But I'm going to submit everything into the record to preserve our client's oral argument when this goes back to the LUHAB. So I appreciate your time. Thanks.
I have another question for you, sir.
Sure.
At the Land Use Appeals Board, you presented evidence on the code enforcement cases. Is that correct?
Yeah.
And let me ask my question, please. And you testified that you yourself submitted a code enforcement complaint. Is that correct?
That's correct.
Is that correct on the?
That's correct. Yeah.
Okay. And that information was not before the land use hearing officer. So it was new information you brought to the LUAB that was not before the LUHO. Is that correct?
No, here's what happened, actually. If you look at the application, the procedures manual, it says on the application, are you in violation or code violation? And I'm paraphrasing, so okay, Tom probably has it right there. And it says, if so, attached citations. Okay, and
it says yes or no, and it was answered yes, correct?
It says, if yes, attached citations. Miss Lott, who was the applicant with De Jesus back then, didn't attach anything. So after the hearing, I recognized that it wasn't in the record. And I went through Tom and other representatives of Hillsborough County, Adam Gormley, the county attorney. Ultimately, they were put into the record after the fact.
After the hearing, correct?
Yeah. So
the land use hearing officer didn't have that evidence, but you brought it up to the land use appeals.
I brought it up that there were cases. Now, if you look at the new application, it says, are you in violation? And it's checked. The one before you today, and it's checked yes.
It was checked yes before.
Okay. Yeah. But before, those code enforcement violations were dropped because the variance was granted.
Correct.
Okay. Now you have building code violations, which are apparently are kind of a different animal than like your typical code enforcement. So my point to you today is they checked yes, we're in violation, and didn't attach anything either for your consideration and review. So I think the record's incomplete and they didn't fulfill their obligation under the procedures manual, nor did they fulfill their obligation under just the basic application requirements. Thank you.
I'm sorry, you're saying that there is an open building building code enforcement?
That's what I gave you those. Okay. And you'll see that whatever person, the investigator, inspector concerned about illegal triplex and single family zoning district.
Okay, one moment, Mr. Bentley. All right, looking at the code enforcement cases, I don't see any open at this time.
Okay. And the final thing, if they were legitimately pursuing permits, and what I gave you is the county permit applications, and I think the violation where the county at this point was waiting on comments to some of the plans that they had filed several weeks ago without response. So it's just pure speculation as to whether or not this is going to convert from a triplex to a single family at this point in time. It looks like they really haven't followed through with the county's request to provide information. So thank you very much.
Thank you, Mr. Bentley. County staff, do you have anything further to add?
No, ma'am.
All right, thank you. Applicant? I believe I gave Mr. Bentley substantial time, so if you need additional time, I'll grant it. And also, you might want to bring your client, the property owner, forward, please.
Yes. Look, I started. This is very awkward.
And state your name for the record.
Isabel Albert, 1000 North Ashley Drive. This gentleman hasn't even moved to Hillsborough County and had to deal with all of this. They are aware of the issues and are trying to fix those issues.
One moment, Ms. Albert. Mr. Bentley just handed me a document. Was this provided to the clerk?
Can I see those documents too, please?
All right, Mr. Bentley, come to the microphone, please.
I had mentioned the plans they had filed for the building permit. Those are the copies of the plans that I received from Hillsborough County.
All right, Mr. Bentley, you're putting into the record then plans that you received from Hillsborough County that are the current building permit to convert the property to a single family home?
That's what it appears to be.
Okay, thank you.
Thank you. Mhm.
And Ms. Albert, would you like to see these documents? Mr. Hisney, could I ask you? Mr. Hisney will hand them to you. We'll take a moment.
Thank you. If I could get a copy of all the documents that were provided,
I believe the clerk will scan them in. Is that correct, Mr. Hisney?
Yes, following the hearing, the clerk will scan everything that was handed in. And then, Ms. Albert, if you go into the optics file and
all right, well, it's just like,
time, they'll be listed under exhibit.
right, but I'm on the record right now, so I want to make sure that I see what they have, what he's provided. It'll be too late after. So I wanted to know if I could just see what was just submitted.
That's up to you.
Absolutely. Yes. Do you need a minute to examine those?
So I take it that's everything that you just submitted?
All right, Mr. Bentley, did you provide Ms. Albert with a copy of everything that you just submitted this morning to the record?
No, neither did Miss Albert ever provide me with anything she submitted, but I just gave her a copy of everything I submitted, plus a lot of the old documents in the record.
Okay, so the documents that you just handed Ms. Albert is everything that you have submitted into the record. Is that correct?
That's correct.
Thank you.
And I want to make sure that all evidence from the first hearing is incorporated by reference in this proceeding, okay? So,
Thank you, Mr. Bentley.
right,
You're not recognized right now.
is that
Please step
accurate?
aside.
is that accurate?
One moment, please.
Yeah, the county attorney.
Please step aside just one moment.
Thank you.
Thank you. Mr. Hisney. Mr. Hisney, everything that was submitted at the original hearing, May 24th, 2021, that is in the record. Is that correct?
I'll direct that question to county attorney staff.
Yes, all the original record is in the hearing. Sorry, Cameron Clark, Assistant County Attorney. There's nothing from the first hearing that's not still part of the record, so it can all be reviewed.
Thank you, Mr. Clark.
And I just saw he submitted the conversion to a single family home, right? That's what he submitted, those plans?
Mr. Bentley stated those were the planning or the building application documents he got from the county.
Right.
I believe you're holding those.
They are holding them until this is all cleared up. So right now, like I said, the applicant purchased this property and was under the assumption that what he purchased was permitted. And therefore, when he found out, he took the next step is to make sure that this was going to be converted back to a single family residence. Mr. Bentley has submitted proof, and I have these two. This is all I got from the applicant recently, was just to convert the triplex into a single family home, and I'll put that into the record. That's really all I have because everything else is in the record. I agree with everything that the findings, the original findings, and therefore, and that was shown in the response to when I first represented this new owner. This new owner has never met the Rays. He doesn't have anything against them. So it was pretty shocking and surprising and sad that they're actually going through this. But I also wanted to point out a couple of things. As you also saw, the easement was to provide for those two parcels, and I'll enter that into the record. It was parcel 1, which is for 8710 Hyder Joe Lane, and the second parcel, parcel number 2, that's the legal description for 8704 Hyder Jane Lane. Whether or not what the intentions were, I cannot say. I was not part of it, and the current owners are not, weren't part of those discussions, but they purchased the property based on, the variance for the 20-foot and further, it's a single family home that they're doing.
Ms. Albert, professionally, what are your credentials?
I'm a certified planner. I'm an AICP, and I am a certified planner. And looking at the code, we have the ability to request for a variance, meeting all these criterias for to allow a 20-foot easement versus the 30-foot easement to serve these two units.
Regarding, because I believe there was a question about the 5-foot utility easement, which we now understand from testimony of Mr. Ray, was a utility easement that the Rays granted to Mr. Hyder, and it runs contiguously with the 20-foot wide access easement.
Correct.
Is that your understanding?
That is correct. So,
Okay, and then my question to you is, in your experience as a planner, and I imagine, do you work with development of properties and
I do.
okay. Have you ever had occasion where a utility easement ran underneath a roadway or underneath an access driveway?
That's typically what you will see, yes.
And so even if the roadway, for example, is paved, can the water lines run underneath there and
Yes,
be
they hit.
maintained?
Yes. Yes. They can be maintained. They can go under the roads. You'll often see in subdivision a utility easement along all the frontage of the property line, which goes over driveways. It's typically like that.
So in your experience, is it your testimony then that it's not unusual for a utility easement to run underneath a paved roadway, for example?
That is correct.
In your professional opinion, then, would the placement of a 5-foot water utility easement interfere with using the whole 20-foot access driveway?
No, it would not.
Thank you. Please proceed. Is your client available, Ms.
He is
Teresa?
available. Yes, he's available. And I'm also available if you have any further questions. I believe that everything is into the record. The original recommendation based on these facts in the record. And
Okay. Please have Mr. Jurzik come forward, please. Thank you. And state your name.
Alejandro Jurisic.
Okay. And again, Mr. Jurzik, you are the owner of 8710 Hyder Joe Lane. Is that
I
correct?
am, yes.
And it was your testimony earlier that you are in the process of converting this structure there to a single-family home. Is that correct?
We are, yes.
And it is your intention to move there yourself and occupy that home as your residence? Is that
As a
correct?
single family, yes.
Okay. How do you access that home? What is the access way to get there?
The only access is through Sheldon,
The only access is from Sheldon Road?
to the easement.
If that easement were not there, that easement driveway or roadway were not there, if it were removed, it were taken away, or your right to use it were taken away, would you have access to your property?
No.
Okay.
And neither would the people in the back, 8704.
So the same situation would occur to 8704 Hyder Joe Lane?
It's the only access road for the property.
So those two properties then, 8710 and 8704 Hyder Joe Lane, they would be landlocked with no access but for this 20-foot easement that the Rays granted to Mr. Hyder in 1996. Is that correct?
That is correct.
Okay, thank you. Do you have any other information or evidence you want to put on the record?
No, ma'am.
Okay, thank you. Ms. Albert, do you have any other evidence or information you want to put on the record?
no, thank you for your time.
Okay, make sure those documents get provided back to the clerk. Thank you. All right, that will close the remand hearing then on 21-0586. Mr. Hisney, would you please introduce the next case?
Sure. Okay, we have no reconsideration request today, so that takes us to section F of the agenda, site development variances. First case is item F1, application 21-1372. The applicant is Alliance Realty Partners. They're requesting a variance to encroach into the wetland setback area and also a variance to parking requirements. Staff findings will be presented by Carla Shelton.
Good morning. Carla Shelton with Development Services. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07.b of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on March 1st, 2022, is to allow for construction of retaining walls, buildings, parking spaces, and drive lanes within the 30-foot wetland conservation area setback. The applicant also requests a variance from the parking standards requirement, section 6.05.02.e of the Land Development Code, to reduce the number of required parking spaces. The summary of variances for the wetland setback per the Land Development Code section 4.01.07.b.4. No filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within the required 30-foot wetland conservation area setback. The applicant requests construction of a portion of 2 buildings, retaining walls, parking spaces, and driving lanes within the 30-foot wetland conservation area setback. The applicant requests up to a 30-foot reduction of the setback to allow for a setback of 0 feet in some areas. Parking reduction. Per Land Development Code section 6.05.02.e, parking requirements for multifamily developments are as follows. 1.5 spaces for every 1-bedroom apartment and 2 spaces for every apartment with 2 or more bedrooms. The subject development is proposing 228 1-bedroom units and 108 2-bedroom units, which results in a total parking requirement of 558 spaces. The applicant requests a 62 space reduction to the total parking requirement to allow 496 total spaces, which will include 30 ADA compliant spaces. This represents a reduction from an average of 1.66 spaces per unit to an average of 1.47 spaces per unit. However, some of the spaces that are to be provided are located in wetland setback areas and therefore are dependent upon approval of the requested wetland setback variance. Staff findings. Finding number 1, the plans submitted with this variance request show proposed wetland impacts that have not yet been approved by the Environmental Protection Commission. Number 2, the applicant has submitted a general wetland setback compensation planting plan. This plan proposes a compensation planting area in excess of the required square footage. At the time of the site construction plan review, a more detailed compensation planting plan that includes the species, size, and location of specific plantings will be required to be submitted. 3, the applicant has the option of using Land Development Code Section 6.05.02.g, determination for unlisted uses or alternative parking, to alternative parking process to request a reduced parking rate through an administrative process. Under the current process, this application does not provide an ITE or parking study as delineated by section 6.05.02G. That is all from staff.
Thank you, Ms. Shelton. Applicant?
Good morning, Ms. Hatley. Jessica Iserman, 401.
Oh, one moment. Thank you.
401 East Jackson Street, Suite 2100. I'm an attorney with Stearns Weaver Miller. With me today is Elliot Simmons and Bobby Anderson. They are with Alliance Residential Company. They are behind me today. Also virtually is Ryan Clark with Kimley Horn, who is our engineer. So if you have questions, feel free to ask those representatives.
Thank you.
I have a presentation and I also have a binder. If you'd like to follow along, I do intend to submit the binder into the record.
Okay, I'll accept that now and make sure the clerk has it.
Great, thank you. All right. All right, we are here today for variance WS 21-1372. Next slide, please. This is a general location of the property. The property is approximately 36 acres in size, but over 20 acres of it is wetlands or a man-made lake. The property is located at 10810 East Dr. Martin Luther King Jr. Boulevard. And there's a second parcel that is at 4206 Williams Road. The property is bounded almost entirely on all four sides by roadways. The zoning is a PD and it is in the UMU 20 future land use category. Next slide, please. The property has as proposed, the applicant is proposing 336 multifamily residential units. This is below the current entitlements on the property. PROS is a company. It is Alliance's workforce housing brand that was established in 2018 to address demand for quality attainable housing. The intent is that all units will be workforce housing with luxury finishes. Next slide, please. So as staff explained earlier, we are requesting two variances. One variance is to the wetland buffer setback, and in certain areas, we are requesting a setback or a reduction of the entire 30-foot setback. In some areas, we only requesting 3 feet of a reduction of the setback. The second variance is a request to reduce the number of required parking spaces. Next slide, please. We, as you will see in our application and through testimony today, you'll see that we will meet all of the variance request criteria. Next slide, please. So this slide shows an excerpt of the SwiftMud approved wetland / surface water boundary. The full exhibit is provided in the binder and in the application, but I wanted to highlight it because this shows the extent of the wetlands on the property. So you'll see there are 2 blue circles. Those are upland area number 1. And you can see they are kind of bifurcated, but by what I would call like a heart-shaped area. That is a wetland area. The entire middle of the property is a wetland, or the circle kind of in the middle is the actual man-made lake. It's a burrow pit that was created with the expansion of I-75. Then the southern part of the property that has an orange circle, that is upland area number 2, that is a second upland area, but it cannot be accessed anywhere except internally through the site, because right to the south of it, that is an on-ramp for I-75. So access criteria management prohibits access directly to Dr. Martin Luther King Jr. Boulevard. So you can see this property is a difficult property. It has over half of the property is wetland or a lake. Next slide, please. So this is an excerpt of the wetland impact exhibit. Again, this is in the materials and in your binder. What this shows is the pink areas are actual wetland impacts, and the orange areas are wetland buffer impacts. You can see that each upland area has been utilized, to the greatest extent we can, but by keeping as much of the parking area in the buildings outside of the actual wetland and the buffer. The only direct wetland impacts is the access roadway. There are no buildings or parking areas are in the actual wetland. And of course, EPC will have a separate approval process for those wetland impacts. Next slide, please.
Ms. Eiserman, just to be clear, the main access to the property is from the road to the east. Is that correct?
If you could go to the slide. There are two access points. One is to the north and one is to the east.
Okay. And so the access road impact to the wetland is just connecting those two areas. Is that correct?
Right. It's connecting Upland Area 1 with Upland Area 2.
Okay, thank you.
Right. Next slide. So these are excerpts of that exhibit we were just looking at, just zoomed into each individual impact areas. So impact areas 1, 2, and 3, we are requesting a reduction to 0 feet. You can see we use retaining walls, curb and gutter, etc. There is a separate, and the reason why I say that is because there is a separate stormwater treatment facility. We are not requesting any variances to stormwater or stormwater treatment standards. All of the stormwater will be routed to the treatment facilities. So I just wanted to point that out as a mitigating factor. As you can see, the wetland buffer impact in the pink, that will have to be approved by EPC, but the orange areas is the buffer impacts that we are here today discussing. All right, so impact area 4, we are requesting a setback reduction from 30 feet to 27 feet. So that's a 3-foot encroachment due to the edge of that building. Next slide, please. Again, impact area 5, we're requesting reduction from 30 feet to 22 feet because of the 8-foot encroachment. Impact area 6, 30 feet to 21 feet due to a 9-foot encroachment. Next slide, please. Impact area 7, we are requesting a reduction to 0 feet. As you can see, that's related to the access road, and that is the buffer related to the access road and partly parking as well. Access area 8, we are requesting a buffer reduction from 30 feet to 12 feet, and that is to allow buildings and this is on the south side of this is in upland area number 2, the buildings in upland area number 2. And next slide, please. Impact area 9, that is to allow for parking to reduce the setback from 30 feet to 4 feet. Next slide, please. So again, looking at the wetland justifications, the property is 57, comprised 57% of either wetlands or a man-made lake. So looking at the outlines of the wetland, you can see that there is, extensive buffers because the wetland line is extensive throughout the property. There are no wetland impacts except for the roadways, for the vital access roadways. As we discussed, upland area 2 can only be accessed internally. The variance request only affects wetland buffer setbacks internal to the site. We are proposing enhanced planting areas and a larger buffer in some areas. The applicant has, to this point, we have gone through several iterations of the site plan. The site plan currently is in the process of county review and approval. And of course, we would need this variance to get site plan approval. We have reduced the number of buildings from 14 to 9 by increasing the stories. And that way we can, compress our site more. The variance will result in substantial justice as this will allow for the development of 336 workforce housing units. Next slide, please. And this slide shows the variance request justifications for the parking reduction request. Primarily, we were struggling with the balance of how much parking do we reduce and how much parking do we allow to be in the buffer areas. We came to a reduction of 62 spaces because that still allows 1 space per bedroom and 52 visitor spots. So that was the balance that we struck. Again, allowing this reduction will result in substantial justice as this will allow for the development of 336 workforce units. And with that, I'm going to ask Mr. Simmons to come up no, sorry, Mr. Anderson to come up and speak to you a little bit about Alliance, unless you have questions.
Just a question, and your clients may address this as well, but in reducing the parking spaces, and I know there had to have been a balancing act going on there, but the applicant could have reduced the number of units as well to, could you address that? And that would avoid having to have the variance at all, possibly, or?
Yes, Mr. Anderson will address that.
All right, thank you.
So Bobby Anderson, 222 West Comstock Avenue, Winter Park, Florida, with Alliance Residential. I'm the managing director for all of Central and North Florida. To answer your question, yes, we could. The problem is, as you may know right now, is this is one of the hottest housing markets in the country. And we've got a land seller, and the land seller's got capital partners. And so there's a value associated with this. And so in order for us to deliver truly workforce housing, and this is, we're not getting any assistance, no tax credits. So this is truly in-house. So the trick to this is by bringing the basis down as far as possible in the actual apartment so that we can rent these at levels that people can actually afford and not just the upper 5-10%. And with that, can you go back to the PowerPoint? So here, just a little bit about us real quick, and I'll kind of get into the whole pros and workforce and how that works. You got to.
Thank you. Yes, and in that, would you please address, since you're not, in other words, you're not applying for tax credits or something like that to help finance affordable housing, but you're presenting this as if it's workforce housing, which so please address what percentage of AMI, for example, will be the target residents, and also what will ensure that the rent stays at that level and doesn't increase to market.
Yeah, and if I can give a little background on us, I'll go into the product even more, which will kind of, I think, answer all those questions. So Alliance Residential, we're one of the largest apartment developers in the country and one of the largest real estate companies in the country. As you can see up here is that, we've got offices throughout the Sun Belt. We're usually ranked 1, 2, or 3 as far as the top nationals of delivering projects every year. You can go to the next slide. So about 3 years ago, we kind of noticed, as what everybody's noticed, is that rents are becoming extremely unaffordable for the vast majority of people. And so we've really kind of put our heads together as one of the larger apartment companies to try to figure out what we could do to address this problem, since it's a problem not just here in Tampa where we're at, but also across the country that we're facing everywhere. So we kind of came up with this product of pros of just trying to figure out, we looked at every window, every door, how do we, save a little bit here? How do we make things more efficient? How do we get it done faster in order to bring the basis down and still allow our capital partners, because we have to use institutional capital partners to do this amount of deal, to make a reasonable rate of return, but at the same time provide rents that, are within a acceptable range. So as you can see from this slide here is that we've actually gone to the vast majority of the stuff we do. So in addition to the pros workforce I'm talking about, we do our Broadstone luxury stuff, which you guys have probably seen a couple of our projects around town. We've got a build to rent thing that we just started, and we do senior housing as well. But as of 3 years ago, there was no pros deals there. So now it makes up 68% of our total portfolio and pipeline. So as you can see, we're kind of all in on providing workforce housing around the country. So if you go to the next slide. And then sounds like the affordability problem in Tampa Bay, but I kind of put this slide up there just to highlight just how bad it really is that, with 6,500 deliveries last year and then 10,000 net absorption, is that we had a deficit of 4,000 last year alone, and that doesn't even count the deficit that we were previously in. So there is a ton of need for new apartments, new housing that's affordable, all kind of different options, right, in order to kind of meet this demand and solve the crisis that's currently going on in Tampa. In addition, effective rent was up 22% as of the fourth quarter, and it's even higher now. It's closer to 30%. So I think this kind of highlight, and then occupancy is at a high time rate. So it's 97%. So there's not even vacant units available, even if you could pay, what they're asking. So that's the reason for this. And going back to your question, so the whole thesis behind this and what we've been doing, and it's not a thesis anymore just because we've delivered on thousands of units across the country and are about to deliver on our first 300 units over in the St. Cloud area of Florida right now. Actually get first units in about a month. Is that, this is really targeted at the HUD definition of workforce housing. So it's 80 to 120% of AMI is really what we're shooting for here.
That's right. It's what again?
80 to 120% of AMI.
Okay.
So 80, because anything 80% or below, right, you probably qualify for income restricted. So it's really that next chunk of renters who historically they've rented the older B and C type properties, but because of the lack of available inventory, the B and C properties are now, that are 20, 30 years old are now increasing their rents. So it's really twofold in what we try to do is one, and can you flip to the next slide and kind of at least show? So one, we're building new product, right? So it's new, it feels new, smells new, all those kind of good things. We're doing it in a way that hits the 80 to 120% of AMI. And quite frankly, like in this area, is we expect our rents to be right on top of 20-year-old stuff. So in addition to, providing new workforce housing, is we're also putting pressure on some of the older properties that, if you can rent for the same price, why wouldn't you rent here? So they're going to have to, at best case, at least hold their rents and not raise them as rapidly as they are. And in the best case scenario, they'll have to drop their rents a little bit in order to compete. So, and as
for time, sir, can you wrap it up in a minute?
Yeah, I can wrap it up real quick. So,
okay, thank you.
So as you can see here, this is just an example. I just kind of wanted to show what we provide is that although it's workforce housing, it hits the 80 to 120%. This feels like luxury. And if you can go to the next one, and really the units are really where it kind of shines is, you're talking granite countertops, you're talking shaker cabinets, you're talking vinyl wood plank flooring throughout. So, it's a good product and not just something to build that looks cheap and feels cheap.
Mm-hmm. Right.
Thank you. For your time.
Thank you.
And real quick for the record, I just want to note that the property is entitled for 348 units and it is being developed at 336 units. So there was a reduction to meet this balance.
Thank you, Ms. Iserman.
Thank you.
All right. Is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Please come forward.
I believe we have people online as well.
All right, thank you. All right, please come forward, ma'am. I need you to state your name and address in the record.
This is for the Bryan Road MLK.
This is 21-1372. That's the case number. It's southwest corner of Williams Road and Bryan Road.
I have 21-1378.
That's the application number you have?
BARWS 21-1378.
Is that? One moment, please. Do we have that case?
No, there's not a case with that number on today's agenda. Let's see if that was among those. Oh, okay. So, yeah, that appears you have the wrong case number, ma'am.
You want to see this?
Yes, please. Yep. That's 1372.
Yeah.
This letter is for this case. It's actually 21-1372. So if you're here for this case, that's the one that's being discussed right now.
How many speakers do we have online for this?
I believe we have one signed in. That'll be Thomas Ferry.
Okay, so
I believe we have Eugene Gowerty signed up.
All right, so among those who wish to speak in opposition to this case, you have 15 minutes total among you. And we'll hear from you first, ma'am. Please give us your name and address for the record.
Deborah Russell, 10631 Bryan Road, Tampa, Florida, 33610. I have concerns I want to share with you. Are you planning to raise the ground level? I live in a low level brick house and I would flood easily. Also, if you bring in more dirt and vibrate the ground, my buildings could be damaged. I do not want Estevez Lane open for your transportation. Is Bryan Road going to be your only exit to Williams Road? It's hard enough to get out now. Adding more people would be much harder for this little road. A traffic light would also be needed. Are you going to leave a big healthy trees and leave a tree boundary on Estevez Lane? This land has been a preserve and wetlands for over 50 years. I hope you will show some respect for the wildlife living here. That's what Florida used to be all about. The meaning of preserve is to keep from harm. Recently, truck after truckloads of trees are taken down next to I-75. Where are the wildlife supposed to go? Most will die, and that would be very sad. Thank you for your time.
Thank you, ma'am. Please sign in with the clerk right here before you sit down. Is there anyone else here in the room who wishes to speak in opposition to this case?
I apologize, Madam Hearing Officer. Those people are actually for the next case, the ones that were signed up virtually.
All right. So is there anyone online who wishes to speak in opposition to case 21-1372? Don't hear anyone. No. Okay. All right. Thank you. Development Services, anything further?
Nothing further from staff.
Staff, thank you. Applicant?
Bobby Anderson, 222 West Comstock Avenue, Winter Park, Florida. Just to address the comments and concerns that the neighbor had here is that, on the flooding, so just going through them, on the flooding side of this is that, yes, with this wetland, and especially the amount of wetlands out here, this site needs to be designed in a way that absolutely addresses the wetland and further make sure that, any additional stormwater due to the buildings and pavement and everything else is picked up and contained on our site and doesn't affect any of the neighboring sites. Which is part of what has made this so challenging because if you look at the site plan on this is that, we have stormwater areas outside of the existing pond. So we're creating even more wet areas on the site in order to, store the stormwater treatment and then eventually discharge into the pond at a reasonable rate. Switching over to the vibration side is we are not doing any extraordinary vibration like a vibro type of soil compaction on this. These are 4-story garden apartments, surface parked, no parking garages or anything like that. That would create that. So yes, we'll absolutely monitor the the construction traffic, keep it off the neighboring roads, and keep it directly on the site so that we don't have big construction vehicles going on the site. The other concern, I believe, was the access from Bryan onto Williams, is that we are required to have 2 access points here. The access to Bryan will be a secondary access and resident only type access, which will try to minimize the amount of traffic coming out of that access as much as possible. The main access to this property is directly off of Williams, where we have our clubhouse and leasing center at the front. And then I think the last thing was related to the animals on site and in the wetland. We have conducted an ecological study. We've had our expert go out there. There was no endangered or threatened wildlife found on the property. And in fact, there's a lot of invasive type of plants out there already that really need to be removed from the existing wetland in order to keep those plants from choking some of the stuff, at least how he has explained it to me. So, but we will comply with whatever is required and cleaning up the wetland and everything else out there.
All right, and it was brought up, Estevez Lane, which I see is, a roadway on the west side of the subject property. Do you intend to impact Estevez Lane in any way?
Not at all. So, and in fact, if you look at the shape of our stormwater of how we're doing it, we're actually bringing a pond in between the man-made lake and Estevez Lane, and we have no buildings programmed for back there. All the buildings are programmed for up off of Bryan Road. So we understood that that was a concern for some of the neighbors back there in those single-family homes.
All right, and then the compensation planting plan, you will be doing that, and how will those plantings be ensured to be maintained in the future?
So yes, we will be doing that. Yes, we will be working through our landscape architect to just determine exactly what that means, because I'm not exactly sure. But yeah, we will. I mean, it's in the best interest of us to maintain it, but whatever we need to do, or if there was some kind of agreement or anything else, we'll absolutely make sure that those are maintained.
Thank you. I don't have any further questions for you.
Okay.
Ms. Iserman, did you have something further?
I just want to point out that natural resource staff did not object to the variances. Thank you.
All right, thank you. And this will close the hearing then on case 21-1372. And we're going to take a break. We'll come back at 12:10, please, 12:10. right, welcome back to the March 21, 2022 Land Use Hearing Officer meeting. We're ready to proceed, and I'll just state so everyone knows, we're going to go to about 1 o'clock and see how far we get. And if we're not through the agenda by 1 o'clock, we may go ahead and take a lunch break, just so everyone's aware of that. We'll probably take 30 minutes or so for lunch. So, Mr. Hisney, if you're ready, would you please call the next case?
Our next case is item F2, variance application 22-0381. The applicant is Mark Bentley. The request for a variance to encroach into a wetland setback area. Staff findings will be presented by Carla Shelton.
Good afternoon, Carla Shelton, Knight with Development Services. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07.b of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on December 29th, 2021, is to allow for construction of a portion of a structure, drive lane, and retaining wall within the 30-foot wetland conservation area setback. Summary of the wetland setback variance for Land Development Code section 4.01.07.b.4. No filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of a portion of a car wash structure, drive lanes, and a retaining wall within the 30-foot wetland conservation area setback. The applicant requests a 14.5-foot reduction of the setback to allow for a setback of 15.5 feet. Findings. The applicant has submitted a wetland setback compensation planting plan. This plan proposes 3,000 square feet of remaining 3,000 square feet of remaining wetland setback area to be planted with native plant material. This proposal is double the amount of square footage of encroachment and is double the amount of compensation planting required. That's all from staff.
Thank you, Ms. Shelton. Applicant, please.
Good, here we go. My name is Mark Bentley, 401 East Jackson Street, Tampa, 33602. I represent the applicant. I've been a member of the American Institute of Certified Planners since 1989. That's 33 years. Okay, because I will be giving some planning testimony. I just want to make that clear to you.
Thank you, Mr. Bentley. And you just hand me some documents, and you handed some documents to the clerk. So those documents you handed to the clerk, are they duplicates of what you gave me?
Exactly.
Okay, so those will be in the record.
Yes, ma'am.
Thank you.
Okay. The applicant is seeking a minor encroachment into the wetland conservation setback to allow impervious development that cannot be accomplished without encroachment. Our natural scientist and the county staff will actually have indicated this will be an enhancement when the mitigation plan is actually implemented, as the impacted areas primarily consist of leaves, compacted dirt, and some nuisance species, and a couple of trees. The property consists of 2 folios. I want to walk you through the packet. Maybe that might help you. The property is 2.6 acres in size and consists of these 2 folios here. when the property was zoned, as a condition of the rezoning, and I'll get into that in a second, is this lot here had to remain residential. And like I said, it's almost half an acre, and that's a natural buffer to the neighborhood. Okay, so in perpetuity, that has to remain that way. And the conservation area in question is just right around there, more or less. We received agency comments, and here's EPC, and you can see their comment is current configuration was acceptable. Then in terms of the, this is part of the packet, wetland setback encroachment. Staff went over that. It's basically that you have to submit a mitigation plan. And what we did in this case is, notwithstanding the 1-to-1 requirement that's in the code here, is we did a 2-to-1. And our environmental scientist, Abby Naylor, is going to be talking about that in a second. Back here. Okay. We've provided detailed responses to the variance criteria, and I'm not going to go through those. Those are in your backup, and we'll touch on some of those today. I mentioned EPC, no objection. We must meet the county's setback guidelines. Require the 1-to-1, as I mentioned, the 2-to-1. So I wanted to talk a little bit about, we had met with the neighbors at their request, and we had a really good dialogue and explained the project to them and asked them if they had any questions or concerns to get back to us, and we never did. And I looked on optics and I saw what essentially appeared to be a form letter in opposition, a number of letters, and some of those people are probably here to speak. I think there's a little confusion here about the significance of this hearing. Is it a land use hearing, or is it simply encroachment into the wetland? So I mentioned parcels A is parcel A, the northern parcel is 1.54 acres, parcel B is 0.42. Historically, the property's been used as a gas station with a car wash and other uses. Proposed uses for a car wash, which is a permitted use as of right. So the question of use, which will come up, is not relevant to whether or not a 1,500 square foot encroachment into a general guideline of 30 feet is appropriate or not. We also meet the special use requirements, and I'll show you those right here.
Mr. Bentley, is this the property on Fletcher where there's a little, or there used to be a little farmer's market or something there? Is that property?
Yeah,
okay, thank you.
So what we have here is, here's the approved PD. Ms. Hatley, I've given you a copy of that. Okay. Here's a lot that we've dedicated to preservation, and here's the developable land, more or less. And here's the conditions of approval, which allow the car wash. Then the scheduled permitted uses from the county's LDC, which indicate car wash under the PD, the CN is appropriate. Then the special use requirements for a car washer has to have a roof, and I think at least 2 walls. Okay. So
make sure you're on the microphone, Mr. Bentley.
Stay here. So what I asked the engineer to do, because there have been 2 takings on this property, and you have multiple issues that really impede the development of the property. There have been a taking on Fletcher Avenue. There had been a taking on Rome. I don't have the orders of taking. Okay, those are of record. And so what we have here is, we've dedicated this 0.42 acres then to respect the county setbacks, which are highlighted with these hatch marks here. Then the conservation setback here out of the 2 point. So we had 0.65 acres dedicated to setbacks, 0.74 acres of upland to build on, plus the wetland setbacks. So out of the entire property, we have 26% of the property is actually buildable. But when you look at the property, it has this lineal shape to it. So it's really difficult. And, you know, I've been working on this property and probably zoned it 3 times since 2000 or 2005, more or less. It's really difficult to find a development, okay, that could go on that configuration of the property. So we finally found a suitable development, which would require this minor encroachment into the conservation setback. So that leaves us with this irregularly shaped linear type parcel, with very limited development potential. So to achieve a reasonable use allowed under the zoning, we're seeking agency support of a minor encroachment. This is the area is insufficient between the Fletcher Avenue northern property line and the conservation area to really develop anything of significance. And I just want to point out too, is that, you know, the issue is not the car wash today. I mean, whether or not the proposed development was an office or not and needed to encroach, it's the same issues. And I'm sure you recognize that. What I like to do right now is bring up Abby Naylor, our environmental scientist. And what I've done is I've given you a little report she prepared, her slide presentation, and Abby's CV is in your backup too. Okay, thank you.
Thank you, Mr. Bentley. Be sure to sign in with the clerk.
Hi, good afternoon. My name is Abby Naylor. It's 14706 Tudor Chase Drive, Tampa, Florida, 33626. I'm an ecologist with Naylor Environmental Solutions, and I'm representing our client to look at the wetland setback reduction that we've requested. So on this property, as Mark mentioned, we have a very narrow area in there in which to develop. So that's the request for the reduction in the wetland setback. We are requesting to go from 30 feet down to no less than 15 and a half feet. You can kind of see in that little corner where the wetland line kind of bumps out, that's the narrowest area in which we're going to have a remaining setback left over 15 and a half feet. You can see just to the left of that, there's also an area where it's about 17 feet, and then it just gets bigger, you know, as you go around. The linear distance is about 168 linear feet along the setback line where we're actually requesting the encroachment. You know, as stated in the request, there are no impacts to wetlands. This is just to the wetland setback. And then because of that, and because of the compensation plantings we're proposing, this should not have any effect to any protected species within that area that we're asking for the encroachment. There are not any protected species residing in that area. You know, all of the wading bird and foraging habitat remains. Those were, you know, that statement's kind of based on some comments we got back from the adjacent residents. Can you switch the slide?
Ms. Naylor?
Yes.
The compensation plantings, what mechanism ensures those will be maintained into the future?
Sure. We'll be monitoring them according to the wetland compensation planting guidelines that the county has. So we'll be required to monitor those and make sure that they, you know, survive, maintain, and remain native. So talking about the compensation plantings, we have 1,500 square feet of encroachment. We are doubling the amount of compensation plantings for a total of 3,000 square feet. You know, we've obviously aligned that area directly adjacent to where the encroachment is going to be the greatest. So we're proposing that 2-to-1 ratio, whereas a 1-to-1 ratio is what's required for the guidance. The plants we've selected are obviously all native. They're in the wetland setback compensation guideline, you know, they're from the recommended table of plantings in the county. There are already some wild coffee plants out there, so we're just going to add to what's already existing there. American beautyberry, wax myrtle, and live oak as well. So all of those species are, most of them are already in that area, and we're just going to really be enhancing that buffer area. And they're aesthetically pleasing. All of those, especially the American beautyberry and wild coffee, have fruit that and they flower, so they are also aesthetically pleasing. Do you mind? Next slide. Thank you. So you'll see there on the left-hand side, that is the existing conditions. I kind of tried to do about a 30-foot measurement so you could see what that area looks like where we're looking to encroach and reduce no greater than 14 and a half feet or have a remaining of 15 and a half feet. It's mostly leaf litter right now and bare ground cover. The plants that we selected do well in shade, so they should all survive. And I think it will actually enhance the existing buffer because really there's not a whole lot of vegetation there right now.
All right, Ms. Naylor, then with the limited encroachment into the wetland area setback and the addition of the compensation plantings, is it your opinion that the remaining wetland setback there with the compensation plantings is sufficient to adequately protect the wetland area itself from impacts of the commercial use?
I do. There's also, an existing, I believe it's a 6-foot wall that's located, which right now there's a couple areas where it's breached, and I believe that's part of the development requirement to have that wall in place. So that wall will actually be, kind of border between the car wash and the wetland. And that wall will be improved as part of the development because there's some breaches in that wall right now. So yes, it is my professional opinion that there won't be any effect to the wetland. And in fact, with the additional plantings, it kind of would help support potentially more use by wildlife.
Okay, thank you.
Okay, thank you.
Mr. Bentley, anything further?
Yeah, just on the wall issue, there's a zoning requirement when you get an opportunity to look at the zoning conditions that there has to be an 8-foot wall, masonry wall that's been breached now, and that's going to be maintained. It has to be maintained as part of the zoning. And that was requested by the neighbors when we had zoned the property. So just kind of in summary, we have staff's report, support, EPC support, and likewise the professional opinion from Ms. Naylor. So if you have any questions, I'll certainly try to answer them or get a member of our team. We have our engineers here as well if you have any questions. Thank you.
Don't have any further questions at this time. Thank you. All right, is there anyone here or online who wishes to speak in support of this application? I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, if you're in the room, we'll take you first. Please come forward. We need you to speak into the microphone and state your name and address first.
Good morning, ma'am. My name is Gene Gowerty. I currently live at 13202 Burns Lake Drive, Tampa, Florida, 33612. I am the current president of the Homeowners Association. They've asked me to come here to speak before the board. We request that you deny variance for radiance in regards to this matter for the following reasons. One, the car wash will be located within 30 feet of resident's home. The only thing separating the wall is the only thing separating our homes from the car wash. The wall was broken up in several spots before the fruit and vegetable place. They were going to put a child care center there. It was never fixed. It was never repaired. The car wash will be approximately 20 feet high against an 8-foot wall, which exists here now. Again, within around 30 feet of the homes. The noise will be 7 days a week, Monday through Saturday, 7:30 to 7, Sunday from 9 to 6 p.m. Additionally, the traffic congestion on Fletcher and Rome, which is already designated a school zone due to Hillel School, located maybe 150 feet west of the proposed car wash. For these reasons, and I have 54 signed forms that, requesting to deny the variance, from the homeowners there.
All right.
That's it.
Thank you, sir.
Sure.
Be sure and sign in with clerk. Is there anyone else here in the room who wishes to speak in opposition to this application? Okay. Is there anyone online who wishes to speak in opposition to this application?
Yes, we have Tom Ferry.
All right.
Hello, this is Tom. I live at 13114 Worcester Lane, Tampa, in Burns Lake Estates, in the 38-home residential neighborhood located very close proximity to this imposing, noisy car wash. Yes, there used to be a car wash there long ago. I lived here. It wasn't, I don't even believe, as tall as the wall. It was one of the small ones. You didn't even know it was there. So Mr. Bentley, to say he's putting a 24-foot, 80-foot long, 26-foot wide building in place of that, that makes much more noise and is much more imposing, is being very deceitful. I went up to Land O'Lakes Boulevard. I took a look at the existing Radiant Express car wash they have up there. And in a location where there's a ton of existing ambient noise from 50 or more feet away, you could hear the motors running from the car wash. When the blowers kicked on, you could definitely hear it. So in a beautiful, quiet residential area like Burns Lake Estates, where the ambient noise is typically almost nothing, to put something like this in and to actually request they come 15 feet closer to the neighborhood is a very inappropriate land use for this property. And if that's what we're trying to decide, is this appropriate? That area is primarily small retail, professional offices like one that went in next to it, the Hillel School, many other kinds of businesses besides this noisy behemoth Radiant Group wants to operate at that location. And it will immediately negatively impact every resident in that area. Property values of those residents start to decay that'll spread through the area. Some people have lived there 20, 30 years, very happy, very nicely in a quiet residential area. Many young people have made new investments in that area. And now for Radiant to put this sort of an inappropriate business in that location with such a negative impact, I'm just asking you, do not approve this variance. And it may not be for this location here to discuss it, but to somehow prevent anybody from ever even proposing putting that sort of a business in a nice, quiet residential area that we have here. Thank you.
Thank you, sir. And is there anyone else online or in the room who wishes to speak in opposition to this application?
We did have a sign up from Marisa Kona, but I don't believe she's signed in. It doesn't seem she's online.
Okay. All right. All right.
Can I say one more thing?
You have, yes, sir. You still have time.
I just wanted to make sure, because you're collecting information at this time, you did receive my email from March 13th at 2:48 p.m. because I did in writing submit comments to the hearings email list. I just want to make sure that's part of the record here.
One moment, sir.
Thank you.
From Tom Ferry.
We're going to have our
I'm J13.
check our optics file. So hold on, please.
Okay.
We're going to check just to be sure.
Okay. And again, Mr. Bentley, the reason he clearly stated car wash is approved and all that, even though we're talking apples and oranges here, is clearly because he never mentioned noise, never mentioned the actual impact of that business. And he knows that's the main issue here.
Ferri, Ferry, Tom Ferry. we do have your document in file, sir.
Thank you.
All right, thank you. Development Services, anything further? Staff.
Nothing more from staff.
Thank you, Ms. Shelton. Applicant?
Ms. Hatley, this is what I showed you previously, just to identify certain areas of the property that were subject to setbacks, et cetera. The first gentleman indicated that a home would be within 30 feet. And what I'm pointing to, the width, this is the conservation, and that's 30 feet. So there are really no homes within 30 feet that we're aware of. Secondarily, Fletcher is a major arterial, okay? And the bulk of the comments seem to relate to the use of the property. I didn't want to get into land use issues because here again, it could be any use. And really the focus of this hearing today is our application, the four corners of the application on the encroachment for 1,500 square feet, whether or not that would have an adverse impact on the conservation setback area and the wetland. In any event, the development is going to respect both the EPC noise rule and the county's noise ordinance. And most of the activity in terms of vacuums and things like that are going to be oriented toward Fletcher Avenue. In our meeting with the neighbors, that issue had come up and we addressed that and we told them exactly what our intention was to minimize any impact on the neighborhood. That's why everything's oriented to the north. So here again, we have all the agencies in support, and really kind of the problem here from our perspective, it's not really a problem, is that the neighbors are really concerned about the use. And with all due respect to the two neighbors who testified, I didn't hear that they had any qualifications to testify on the natural resources or environmental issues. So thank you very much for your time.
All right, thank you, Mr. Bentley. That will close the hearing then on application 22-0381.
Okay, that concludes our site development section F. We do not have any side variances, so that'll take us to section 8H of the agenda. We have the first case is item, it's marked as H2, and it is variance application 21-1248. The applicant is Perez and Del Rio, and they are requesting a variance to lot development standards. Staff findings will be presented by Israel Monsanto.
Good afternoon, Israel Monsanto Development Services. This application variance 21-1248. The applicant is requesting a setback variance to accommodate a covered patio attached to a single-family home on a property zone RSC 9. Per the LDC section 601-03I4, covered patios may intrude no more than 13 feet into the required rear yard and shall not intrude into the required side yards or front yards. Per Land Development Code section 60101, for this zoning district, a minimum of side yard of 5 feet is required. The applicant requests a 4-foot reduction to the required side yard setback to allow a setback of 1 foot on the east property line for the covered patio. Staff findings: principal structure is placed 9.75 feet from the east parcel line. The subject covered patio was added along the east side of the house and is 8.75 feet, which is roughly 8 feet and 9 inches wide by 40 feet long. The covered patio was built by the property owner with no building permits. The owner has been issued a violation notice and is in the record CE 200-11039. This is the eastern property boundary. This is the covered patio with the post noticing these dots. The green line is the required setback, which is 5 feet from the side yard. The property owner encroached 4 feet, leaving only 1 foot of setback on the side yard. And this concludes staff presentation.
Thank you, Mr. Monsanto. All right, applicant?
John Zonate, 503 East Jackson Street, 33602. Representing Ms. Perez, excuse my voice, just got over COVID, so I'm just working. So, just to add to Mr. Monsanto, we have also letters from the east and the west, or the right and left side of the property owners that have no problem with her constructing what she did on the property. We also submitted documents with Mr.
Hisney?
Excuse me.
What was your question, sir?
No question. We also submitted documents which you already verified to the Pittsburgh County zoning. And we also applied to all the requests made by your office. We also have a code violation, which is the same thing that they just got yesterday, which I think needs to be removed because it's the same code violation which we already applying for now. So do I need to submit this?
Is that a copy that you can submit?
It's not a copy, but if they can, you know what, I can pull it off as a copy. Yes, I can.
Okay, thank you. And you can leave that with the clerk.
Okay, and do you need me to also submit the letters from the neighbors? Well,
yes.
We have 9 neighbors that approve. They have no problem with what the Perez's are doing. They've been residents there for almost 5 years.
Okay, so submit those to the record as well.
Okay.
And could you discuss the hardship criteria?
Okay, the hardship criteria comes in as an effect. They did this during the height of COVID season. And all they did was construct a carport kind of area over so they can have somewhere to go because there was so many people in the residence. And they just wanted some place to get outside the house and have recreational place to subside at. And that was it. They asked their neighbors adjacent to them, would there be a problem with their construction? They said there was no problem doing that from the neighbor to the left and to the right. They also wrote letters in conjunction with what they were doing, and they approved of it.
So regarding the property itself, the shape of it, or any development of the property that's already there, is there some reason why the covered patio could not have been built, for example, on the other side where it wouldn't have encroached into the setback, or maybe on the rear of the property or something like that?
We did it in sawing what other properties did on that street as well, but also it's right out where the patio door is. So the other side has concrete walls, and then they would have to actually remove a concrete wall to make access for a door to go into the patio, or actually go around all the way around the property to access another part of the property. So I guess that's why they put it, because it's adjacent or right next to where they can have quickest access to it.
All right, and the current property owners actually added this structure without permits.
Correct. They did not. They were not aware of adding permit because they saw other residents at that time, COVID time, that put up other similar structures to it and saw that it was okay. We can do that the same. So they were not aware of it. They called me. We constructed the documents that they needed for Hillsborough County request, signed, seal, engineering documents for everything they did and everything they constructed.
I'm sorry, after the fact, you mean?
Yes, after the fact. I'm sorry.
Okay. Are you an engineer or architect?
In my firm, I have an engineer and architect. I own the firm.
Okay. On the east side, the structure is 1 foot from the property line. Is that correct?
Yes, it's actually 2 foot, but 1 foot from the adjacent fence and 2 foot from the property line.
Okay. Gutters for storm water control, that sort of thing?
Yes.
Okay. All right. All right. That's all the questions I have. Anything further you would like to add?
No, just to submit the the applicants for the neighbors, and then to submit the other violation.
So all the documents you have to submit, please leave them with the clerk here and sign in with the clerk. They'll take them.
Thank you.
Okay, thank you. All right, is there anyone here or online who wishes to speak in support of this application? All right, is there anyone here or online who wishes to speak in opposition to this application? You need to come forward, please. Is there anyone online? No, okay. So I see one person in the room, is that all? Okay.
Hi there, good afternoon. My name is Carolyn Kelly, and I reside at 4542 West Paris Street, Tampa, Florida. And I am here today to speak about 21-1248. It appears a new application was filed on February 21st, but only one of the property owners was included in that application. They did, in the new application at the variance criteria response, item 3 states, we asked the permission of our neighbors before we constructed the open patio, close quote. The property owner that is not now on the second application is the owner of a restoration and remodeling company. And it's been in business for the past 6 years. The state of Florida shows that the business is operated at 4528 West Paris Street, Tampa, Florida. Since he's currently working in construction, one could only think that his building to the property line is a hardship which he created. It's my understanding that if the hardship is created by the property owner, a variance should not be granted. I'm opposed to the granting of this zoning variance based on this information and offer the attached materials for the record. Thank you for your time.
Kelly, where is your property in proximity to the subject property?
They are at 28 and I'm at 42.
Good, thank you. If you have materials to submit, you can please provide those to the clerk. They will get in the record and I will see them.
Okay.
And sign in with the clerk as well.
I will certainly do that, but I would like to also make one comment. Earlier, you asked about the drainage on the attachment. Right now, the guttering system is located between the attachment and the main roof system. Okay, the guttering is not on the edge of the property. It is.
You're saying
there's a guttering system that was on the house at the time the attachment was included, and that guttering system still remains there.
All right. And so as far as you know from what you've seen, there's no guttering system on the outside that connects to the adjacent property.
And the other thing is too, in the setback, you have to consider that the roof overhang is approximately 1 foot. So by the time you do that, you're literally only granting the 1 foot, not 2 feet.
Okay.
And I think that's all I have to say. I thank you again for your time.
Thank you, ma'am. 1 moment, sir. In 1 moment. Yes, you will. All right. Is there anyone else here in the room or online who wishes to speak in opposition to this application? All right. Don't hear anyone. Staff, Development Services staff, do you have anything further? Mr. Monsanto, does staff have anything further? Okay, 1 moment.
Israel Monsanto Development Services. I want the applicant to clarify that the setback is for 1 foot because there is only 1 foot to the property line, but there is a fence that's placed at 2 feet. And I think that fence is either a chain link fence or a wood fence, just to make.
Thank you, Mr. Monsanto.
In response to her reply about the gutter, the attached portion of the carport or the structure is tilted at an angle, which is, it makes the runoff come toward that particular gutter.
I'm sorry, you mean it's angled?
It's pitched at an angle.
Wait a minute, let me ask my question.
Go ahead.
So the roof of that structure that was added, patio, is angled back toward the house?
It's angled back toward where the gutter lies at, and then they have a separate gutter that's added to the front part of it.
Okay.
So the water pitches inwards toward the street, and the water pitches also outward toward the roof line.
All right.
Current roof line.
Let me ask it again, and please listen to my question.
Okay.
One moment. Did you give those to the clerk?
I did. I just wanted to say.
Okay, thank you, ma'am. I will see those. Thank you. All right, I'm going to make my question again. All right, the house is on the south side of Paris Street.
Correct.
And it faces north.
Correct.
And the patio is on the east side.
Correct.
All right. Is there a gutter between the patio and the roof structure of the house?
There's a gutter in the front portion of it.
The north?
Yes.
Okay. Is there a gutter on the east side of the patio?
Which is the end portion of the patio, correct?
Adjacent to the adjacent property?
No, it's not.
No, okay. So then tell me again how water drains, please.
It would drain from the tilting of the carport. It would drain from the, if I'm doing it right, east line, correct, inward toward the existing roof where the remaining gutter is.
Okay.
Which will catch the runoff toward that, so the runoff doesn't proceed on the other person's property.
Got it.
That's why they signed a letter saying they were okay with how the property was built.
Okay.
I mean, how the structure was built. Now, according and to revert to what she was saying about the, let me remember, concerning what the, Mr. Perez employment is, he's a carpenter. Okay, that's interior. That's what he does. He specializes in interior carpentry work. So that has nothing to do with the exterior work that was done on the property concerning to what she was respecting to about him being in construction. As you know, there's several types of construction. Interior construction has nothing to do with exterior structure, bounds, setbacks, et cetera, et cetera. So that's one thing. Another thing is she's made several different complaints against several neighbors on that block, all of them being Latino descent. So she has a record in the county of harassing almost every neighbor on that block.
Okay. I'm sorry. The applicant's agent, I didn't get your name. I'm
John Zonate.
Fuente?
Zonate.
Fuente.
Yes.
Could you please address staff's question
Yes.
about the distance for the setback that your client needs?
Yes, I think we discussed it several times. So it's actually a 1 foot setback that they need.
Is it a 1 foot from the property line or from the fence?
It's a 1 foot, I believe. Is it from the property line, right? It's 1 foot because we discussed this at length. And I think it's on the right here.
All right, just take your time because I need you to speak into the microphone.
I'm sorry.
And if you need to go to the other microphone, turn this one off and then turn that one on.
Okay. Got it. Okay, can you see that?
Yes, sir.
All right, as you can see, it's 1 foot from the property. It's 1 foot from the actual concrete. It's 1 foot from the property line.
The actual concrete is 1 foot from the property line.
Correct.
Okay, one moment. Is the fence on the property line?
Yes. You have two fences. One fence is on the outer side, one fence is directly on the property line. That's where the adjustment comes from, 2 to 1 foot. Measures out to, I think, 9.9. Yes. As you can see here.
Okay, that's helpful. Yes, thank you. All right, so you actually do need 1 foot.
Correct.
Okay.
And that's,
okay.
Like I said, the adjacent owner that has the wooden fence on the other property line, he already approved it. They have no problem from the left to the right side of her property, which letter's already turned in for submittal.
One more quick question. I'm looking at that picture and I see a chain link fence and a wood fence.
Correct.
So the chain link fence, is that on the property line?
Yes.
Okay. All right. I understand.
Okay.
Don't think I have any further questions for you, sir.
All right. Thank you.
Thank you. All right, this closes the hearing then on 21-1248. We're going to take a lunch break. We'll reconvene just a second. It's almost 1 o'clock. We'll shoot for 1:40. So, Mr. Hisney, did you have some? Oh, wait a minute. Please don't leave. Just 1 moment.
Sorry, I was trying to get.
Speak in the microphone so we can hear you, please. Just a moment, please.
Yeah, we're looking into the issue that was raised by the woman testified in opposition as to whether both property owners had signed the application. And it appears they had not. I understand one of the property owners, the one who did not sign, is in the room. So I was trying to get in touch with our county attorney staff on that question as to whether the property owner who had not signed the application could testify here at the hearing that, she is authorizing the application. Unfortunately, I'm having a little trouble getting through.
I can hear you, Mr. Hisney. This is Cameron Clark. Is there anything about, I don't know, and this might be something that'd be hard to answer on the fly. Is there anything about the changes, the footprint change so that it would the notice radius as far as we know?
I'm sorry, I couldn't understand your question. Bad audio here. Ms. Hatley, did you understand what you said?
Mr. Clark, I think what you're asking was, is there anything substantively changed in the application? And I think my understanding there isn't. The only question is whether the application is properly to go forward with only one of the property owner's signature. But apparently the property owner who did not sign is here in the room. So can we proceed with the application or not?
Okay, so, Mr. Officer, I take it possible that you're going to be able to hear me better than Mr. Hisney is, so I'll state this as best as I can. In general terms, we're okay with someone coming to the microphone and stating.
Yeah, hold on. I've just been told by our tech that the original application was signed by both property owners. They later submitted a revised application on that one. Only one of the property owners signed. So the original application was authorized by both property owners.
Can the other owner, since you have both signatures on the original, can the other owner go on the record and state that they are agreeing?
Yeah, they are in the room, yes.
And they can, if they would come to the microphone by themselves and state they are agreeable to ended application.
All right, so we've reopened the hearing on application 21-1248. That hearing is reopened and we need the owner to come forward, please. If you did not sign the revised application, come forward and state on the record that that revised application has your authorization. You are in agreement with it. Come forward and state your name and address in the record.
My name is Guillermo del Rio. Um,
Okay, you're Guillermo Del Rio?
yes,
Okay, un momento. Dirección,
4528 West Paris Street, Tampa,
Alright.
Florida.
4528 West Paris Street, Tampa, Florida, correct?
Yes, correct. Sorry.
And, all right, you have an interpreter?
Yep.
All right, please come forward and state your name and address in the record.
Norville Ramos, 7818 Cameron Avenue, Tampa, Florida.
Okay, did Mr. Del Rio sign the revised application or no?
Dice que si tú
Okay.
que si firmaste la segunda aplicación.
Okay, what I need is for Mr. Del Rio to state on the record, and you can interpret for him, to state that he is in agreement with the revised application that was submitted on his behalf, and he agrees with that application.
So I'm gonna ask.
Mhm.
Dice que si tú estás de acuerdo con firmar la aplicación, la revisión de la aplicación.
Sí. Yeah.
Yes.
Okay, he understands and he is in agreement with it.
Yeah, I understand.
Okay. All right, that's what we needed. Thank you. And I need for him to sign in with the clerk right here. Just name and address.
Necesita firmar ahí.
Does that cover it? All right, I think that corrects the record. And we are closing the hearing on 21-1248. And we're going to take a lunch break and we'll try to be back here, let's say 1:45.